Good morning. Happy Thursday. For those of you who aren't aware, the Earl Warden trial was continued to July, I think July 13th, somewhere in there. So it was bumped. Word has it that it was bumped due to there being a felony murder trial that took precedence. Probably the defendant didn't waive time. You have a right to a speedy trial, and my guess is the defendant didn't waive time, so they needed to get that trial done before time ran. The prosecution has a certain amount of time to bring the case to trial if you don't waive time. It's my guess. I wasn't there. I don't know all the details. I'm getting a lot of the stuff second and third hand, so who knows. Earl did show up to court reasonably well dressed. A nice blue suit with a really bright pink tie and handkerchief in the pocket. I think it's probably fine. It was a little bit ostentatious for what I would recommend to a client. I prefer my clients to show respect to the court and not bring too much attention to themselves. They, in my opinion, they should be somewhat indistinguishable from the attorney, because you don't want the jury to really think about anything other than the facts that are being presented. And juries place a lot of weight onto how the defendant carries themselves during the trial, their reactions to victims or witnesses saying things, and how they dress. If they're not dressing like they're taking the trial seriously, that can change the opinions of jurors. And generally speaking, as the attorney for a defendant, you want to avoid that. Now, I do my best to avoid criminal matters. I've been involved in very few, thankfully. But it's something that you even think about in civil jury trials. You want your client to not really attract a lot of attention to themselves and look like they're taking the whole process seriously. Because you got to remember, these jurors are taking time out of their lives for usually peanuts, like $5 a day or something dumb like that. And they may not want to be there. And, the state's telling them that this is serious. And then you show up to court dressed kind of clownishly, like you don't take the matter seriously. And that might irritate or offend them. And you just don't want that. You don't want their verdict to be swayed by something like that. And people can be petty. So, but every time Earl goes to court, it gets better. He had that really disgusting looking turtleneck under a blazer the first time. That looked like garbage. And then he wore that weird fabric-y suit that looked hideous. So this time, he's improving every time, and just so you know, I'm not in Earl's corner, but I want him to have a fair trial. If he gets found guilty, I want him to be found guilty because the evidence says he's guilty. I don't want him to be found guilty because he had a bad attorney. I don't want him to be found guilty because he makes terrible choices in how he dresses himself. I want him to be found guilty because he's guilty. Or if he's not, if the evidence doesn't support a guilty verdict, I want him to be found not guilty. So, that's just silly me wanting the system to actually do its job and work instead of giving a circus judgment, which too often happens. On to other things. What's his name? Diddlin' Jack. Texas Sheepdog 72. Diddlin' Jack made a community post where he was displaying his driver's license. In Texas, under the transportation code, if you are a motorist, you have to, and you're stopped, you have to display your driver's license on demand by a magistrate or a peace officer. And the word used in the statute is display. And Jack was like, well, what do you think? Do I have to actually give him the ID, or am I okay just displaying it? And there's two parts to that. There's two parts to the answer to that. There's generally speaking two parts to everything, right? Legally, is he required to? I looked on Google Scholar. I don't have access to a law library, or at least I'm not going to take time to go to one. So I didn't have it, I couldn't really do in-depth research, but on Google Scholar, I looked up Texas Court of Appeals decision, Court of Criminal Appeals decision, and I couldn't see anything where they define display as anything other than just display, as in, you show it to them in such a way that they're able to get all the information off of it. Now, could a court come to the decision that yes, in fact, you actually have to hand it to them so that they could run it through, run the magnetic stripe on the back through a reader? They could, yeah. So I would be careful about doing it. But does it appear currently that you actually have to hand it to the cop? No, it does not. Legally. Now, should you hand it to a cop? Well, you got to remember that when you're stopped, you're kind of at the cop's mercy. The cop can choose to give you a ticket, or he can choose to give you a warning, or he can choose to just say, thanks, have a nice day. He can choose to have to have reasonable suspicion to get a dog down there to do a sniff, right? He can choose to do that, or he can choose not to do it. He can write down the information, go back to his vehicle, and choose to accidentally misenter it and have to come up and reconfirm. And you have to display it to him again, because you have to display it to him on demand. And he could choose to do that multiple times, and he's not extending the stop unreasonably because, well, he's a little bit dyslexic. And if he could just run the card through the reader, then it would go super quick, but you're not allowing him to do it. And so, just taking the time it takes. So sorry, buddy. I'd hate to think you were in a hurry. This is going to take as long as it's going to take for me to get it right. So generally speaking, I'm not a big fan of being a jerk when you are the person in a position where you don't have the power over the situation. It reminds me of a lesson that I learned very early on as an attorney. I was working for an attorney who has a bunch of associates, or had a bunch of associates. I don't know if he still does. And he would like to do what's called papering the opposition. And papering the opposition means that you do a lot of discovery over things you don't really need to do discovery on. And you just throw a lot of paper at him, and you make him respond to everything. And one of the things he liked to do, he called them 1, 2, 3 interrogatories. And for each affirmative defense they'd assert, you would write 3 interrogatories. The first interrogatory for each affirmative defense, the first one would be, state all the facts that support your first affirmative defense. Then the second one would be state all the people who have knowledge of the facts that support your affirmative defense. And the third one would be state all the documents, identify all the documents that contain the facts that support your first affirmative defense. And you do that for each one. And the object wasn't to get information, because I don't think he ever once used those for anything. And I never once saw anybody actually respond to them in such a way that you could get anything reasonable or informative from it. But he did it every time because, number one, he got to charge a client for it. Number two, it didn't affect him because he had an associate deal with it. And number three, in his mind, he thought it was annoying opposing counsel. And opposing counsel would generally respond in kind, and they would send a ton of paperwork to him. And he didn't care because he just farmed it out to an associate. And the associate would be billing the client for the time. And so he's getting paid for it. So, it's just win-win-win for him, right? And it never even dawned on him. It never crossed his mind that opposing counsel also didn't care, because opposing counsel was getting paid to have an associate work on it, right? The only people who cared were the clients who had to pay for all this bull crap. Some attorneys are terrible. Anyway, so I learned that lesson fairly early on, that you don't want to do things if you're not in a position of power. If you're going to be a jerk when you don't have power over opposing counsel, they're just going to be a jerk back, and it's going to make the situation worse. If you're going to be a jerk to a cop when the cop has the right to stop you and keep you there until he has done his investigation, is that really something you want to do? So, you should really think about that. And that brings me to one other point. I know I'm running out of time. I try to keep these under 10 minutes, and I'm just too big of a talker. The other point is Jeff Gray did a video where he said that cops were stopping people without reasonable suspicion for alleging moving violations that didn't exist, just to get people's IDs. And then he goes down there and he has his dash cam going. I mean, he does everything by the book. You hear the blinkers going. I mean, he does everything as far as I am aware, not having any knowledge of Florida traffic laws. As far as I'm aware, it appears he did everything right. He would be the textbook driver. And the cop still pulled him over. And in response to Jeff Gray's questions about, what reasonable suspicion you have, it was like an illegal backing up into the street from a driveway and failing to signal properly or something along those lines, failure to stop. I mean, it was just all bullcrap, right? And Jeff Gray could have been a complete jerk about it. He could have been. He wasn't. He did ask for a supervisor, but he was not being a jerk. And I think that's really the appropriate kind of thing to do when you're being stopped. Don't answer questions, but don't be a jerk. I think if they demand your driver's license, you're going to end up giving it to them. Or they're going to arrest you. You're gonna. And it doesn't matter that you have a dash cam. The cop can make a reasonable mistake of fact. He can make a reasonable mistake of fact. He can say, it looked to me like he didn't stop behind the line. I don't care what his dash cam say. When I was watching, it didn't look like he stopped behind the line. So I thought he ran the stop sign. And then what? What are you going to say? Well, the dash cam shows he didn't. The cop says, that's when I looked at it, my vision. What I saw, it looked like he ran it, optical illusion maybe. And the court's not going to do anything to the cop. I mean, they're just not, because people make mistakes. Cops make mistakes. And the cops can be like, well, you thought you ran the red light. All you had to do was show him your ID and you didn't do it. So you're the bad guy. Ugh. So don't talk to the police, but don't be a jerk. That's my advice. Don't talk to the police, but don't be a jerk. If they ask for your license and registration and proof of insurance, hand it to them. There you go. Hand it to them. They can't say that you failed to give it to them at that point. They can't say that you obstructed them at that point. They can't say that you did anything that would cause them concern for their safety at that point. Don't give them any ammunition. Don't give them anything to work with. Don't answer questions. Don't be a jerk. Just hand them. Just don't talk to them. Really, just say, why'd you stop me? Do you know how fast you're going? I don't answer questions. Am I free to go? Can I get your license and registration? Okay, here you go. Let me know when I can go. And that's it. I mean, don't be a jerk. You get more. The saying is, you catch more flies with honey than you do with vinegar. Whatever. But just don't be a jerk. Anyway, thanks for watching. Have a great day.